Now, the Constitutional Court has ruled in favour of Coronation in its protracted battle against the South African Revenue Service. The matter has been dragging on since 2012 and relates to South Africa's controlled foreign company rules and the Foreign Business Establishment tax exemption. The ruling could potentially affect all SA firms with foreign businesses overseas in determining how their tax is calculated. Legal writer for Business Day Editorial, Tauriq Moosa, joins us now with more. Tauriq, a pleasure. Good afternoon.
Thanks for having me.
Tauriq, maybe you can start off by giving us a background of this case. It has gone on for quite a bit, even reached the Apex Court. Just help us understand what the dispute was really about.
So initially what occurred was that Sars did an audit of Coronation several years ago, and it determined that Coronation's Irish subsidiary was not exempt in terms of tax law. Coronation had set up this Irish subsidiary in about 1997, and it had taken advice from proper tax experts like PwC, etc., who advised Coronation that this was what's known as a foreign business establishment. Now, in terms of South African tax law, foreign business establishment is exempt from a number of tax implications. So SARS can't tax you, contacts that foreign establishment. And Coronation went off the advice of, PwC and other experts. However, SARS, when it did its own audit of the Irish subsidiary, determined that it actually did not fall into the parameters in terms of tax legislation, primarily for a variety of very complicated reasons. But for example, SARS said that the business in Ireland was actually outsourcing to UK and South African companies. So the business wasn't being done in the Irish subsidiary, it was actually being done overseas. And it sort of implied that it was kind of a placeholder in Ireland. And so then it said, as a result of this, it looked at the tax year, I think from about 2012 to 2017, thereabouts. And in that calculation, SARS imposed a tax penalty of almost 800 million rand. Coronation, of course, appealed this and then took it to the tax court. The tax court ruled in Coronation's favor, but then SARS appealed and that landed up in the SCA last year. The SCA then ruled in SARS's favor, which then implied that there was this almost 800 million tax fine, obviously plus interest, against Coronation. Coronation then appealed to the Constitutional Court, and that was handed down on Friday. And the importance of it is, according to Coronation, was that, of course, that it was going off the advice and the understanding of foreign business establishments that had been long accepted by not just itself and its own practitioners, but a bunch of other very heavy hitters, such as the top 50 JSE listed companies. And so if they were operating under the same definition, the same presumption, it would have had a massive impact on all those companies and, of course, South Africa. And that's why it had to go to the Constitutional Court to clarify whether or not the business it had set up, in its understanding and others, was actually exempt.
It is also interesting, I think, Tauriq, when we think of the impact that this will have on multinationals, like you've mentioned, the precedent that has now been set. Help us understand that one. I think it's an important one for many businesses who might even be thinking of moving offshore, but are from South Africa.
Yeah, so interestingly, that was actually one of the considerations that Justice Majid, who wrote the unanimous judgment, pointed out. He said that it was a very narrow reading of SARS's own sort of legislation. It did, because the whole purpose was this stemmed back right up to the beginning of South Africa's democracy, when foreign markets started opening up to South Africa, and this foreign business establishment was established to try and balance the freedom of the open markets versus the control that needed to be had by local businesses. It was a very tight balance, and that's why it was established in the first place. And what the judgment now sets precedent for is clarifying what that means in modern times, because SARS's reading was too narrow, according to the court, and failed to understand the purpose that what the legislation was saying. And importantly, it also solidifies the views of all the companies prior to this judgment and says that these companies' interpretation was correct and SARS was wrong. So it protects and solidifies national, local, and international business interests, which was of concern to the court and also just in terms of the legislation itself.
Also, then I want to talk, I guess, about the windfall that will now emerge, Tauriq, for a coronation here. Of course, they would have raised this provision, as they would have said, in their financials for quite a while. But it looks like this case is done and dusted for them, and that can be a payout for shareholders.
Yeah, so according to one of my colleague who wrote the article, indicates that Coronation is likely to receive this gas injection, and will give it back to will be returned to the shareholders, because naturally this has been an ongoing sort of Damocles for the last few years, because obviously Coronation was threatened with losing out on almost 800 million rand that obviously had not accounted for. And in fact, I think it was a day before the judgment came out, Coronation had even sent a warning to shareholders to be aware of this, because obviously if the judgment came down against Coronation, it would have a massive effect on shareholders. But naturally, they withdrew that statement once the judgment was actually ruled in their favor, which is rather unusual, because the Constitutional Court usually doesn't go against the SCA when it comes to commercial matters. But in this case, they unanimously did.
I mean, with that said, Tauriq, has this been worth it, I think, for Coronation? Of course, not the financial implications. I think that's its own thing here. But going through all of these links, taking this matter all the way to the apex court here, is it also maybe telling to businesses in South Africa that it is worth it to take it all the way to the top, just to have a very specific and niche issues like this well clarified?
It's a very difficult decision to make, because when you're fighting all the way from the tax court to the apex court of the country, aside from the sort of potential fee that you're fighting over, you must also remember that they're incurring legal costs, and that's going to be huge in this case. And even if they win, and even if they get legal costs, it doesn't mean that all of their legal costs are going to be covered, because Sars's case was not ridiculous. It wasn't an abuse of the court system, as we saw the SCA ruled in Sars's favor. So this was a legitimate issue that needed to be ventilated because of this disparity. And when making a decision like this, it's the lawyers are going to say, this is an issue that needs to be fought. But to fight it all the way to the Constitutional Court, and this is a rare victory, particularly on this level, and particularly against the SCA from a unanimous Constitutional Court. And even to hear a case at that level is very rare.
Well, Tauriq, always a pleasure hearing from you. Thank you so much for taking us through the ins and outs of this development. That was Tauriq Moosa, legal writer for Business Day Editorial.